Episodes 1 and 2 of Burden of Proof, One Man's Fight to Show He's Innocent are already out, so go listen to those if you haven't yet. This series discusses sexual assault and contains language that some may find offensive. Listener discretion is advised. After Federico Lowe-Bey was sentenced to 85 years in prison, he became a student of the law. He refused to accept his fate and claimed he was innocent of the crimes he was convicted of. The victim's identification was enough to convict him of rape, sodomy, and tampering with a witness. He was looking for a way he could prove it wasn't him. DNA technology was very new in 1988 when Federico was convicted. The first conviction in the U.S. based on DNA evidence was the year before that. There was a small amount of biological material obtained in this case, so it was never tested, not even for blood type. The criminalist testified at trial that he risked getting a false positive or a false negative since there was so little. Around a decade later, DNA became a serious tool that law enforcement could use to investigate crimes. That opened the door to someone like Federico. The biological evidence from the rape was sitting in an evidence room somewhere in the St. Louis Police Department and could theoretically be tested. Federico started studying how we could get some movement on the case. He had to become a self-taught jailhouse lawyer to learn rules and procedures, all the legal stuff. He treated the entire prison like it was his library, 24/7. He explained it to me, and you can tell I didn't quite understand at first.
You know, I go to the University of Missouri, man. You know what I'm saying? This is where you have to study at, man.
The University of the Department of Corrections?
Yeah, no, the University of Missouri.
Oh, really? You were actually going
this is University of Missouri, not the Department of Corrections. This is the University of Missouri. See, because when you put your head together on the issues that you have to be focused on, this is called a university, and this is the library.
The rapid advancement in DNA technology made testing in Federico's case a real possibility, despite the small amount. The first hurdle was getting in front of a judge. The St. Louis Circuit Attorney's Office opposed testing and filed a motion to dismiss the case. The circuit attorney claimed DNA testing would not prove Federico's innocence. They claimed the DNA collected did not belong to the rapist, and therefore Federico didn't have a claim for the evidence to be tested. The Missouri Supreme Court rule allowing prisoners to petition a court for DNA testing was brand new at the time. Scott Thompson of the Missouri Public Defender's Office was appointed to represent Federico.
I believe Federico's case was the first DNA testing case on which the Public Defender Office had been appointed to represent the movement.
Thompson has been a public defender since 1995. He works in the appellate division, which began to involve post-conviction DNA petitions. We met for an interview at the Missouri Public Defender's St. Louis division. Thompson's 11th floor corner office overlooks the federal courts building and Highway 64 in downtown St. Louis. It's a great view. Thompson started on Federico's case in 2002.
He understands his case, I think, better than most people do, most defendants do. He had a lot of good ideas, and he was really a pleasure to work with.
He said they faced pushback from the state from the very beginning.
I don't know why they were so dead set against it. I mean, they use that same technology to convict people day in and day out, so why wouldn't they want what is, DNA testing, what's widely considered the sort of gold standard of forensic scientific evidence?
Centurion Ministries had researched Federico's case over the previous few years. Founder Jim McCloskey had interviewed Federico in person. Federico had reached out to the organization several times, but they told him they didn't have the funds at the time to help him out. But once there was some movement on the case, Federico picked up the phone again.
And I told Jim, I said, "Hey, Jim, I need some help." He said, "What do you mean you need some help?" I said, "Jim, I need some help. I got some action." He said, "What do you mean you got action?" I said, "I got action. The DNA we found, the sperm that they found, the judge's gonna give me a hearing."
Because of that, McCloskey decided it was time to get involved.
Another reason why we thought it was a good time to enter the case was Scott Thompson was just beginning his DNA effort on behalf of Frederico.
They would have to show a judge that the testing of DNA was, one, possible, and two, could bear exculpatory results if tested. Thompson had a DNA expert testify at an evidentiary hearing that DNA testing, if allowed, could in fact point to Frederico's innocence.
We had him come in and testify at an evidentiary hearing to say that this is absolutely the sort of material that could be tested, notwithstanding the passage of time.
The judge ruled after that hearing in 2003 that Frederico had a sufficient claim to have the DNA tested. Centurion found a private lab that was willing to do the testing, Religene Technologies out of New Orleans. The evidence sent to the lab included a vaginal swab of the victim, which allowed them to develop a profile. The type of profile that was created is called YSTR. In layman's terms, it's developed by taking out just the male DNA from biological material. This guy can tell you better than I can.
The most common time that YSTRs are used is in sexual assault cases, specifically when there's a female victim and a male suspect.
That's Eric Hall, a DNA expert at St. Louis University. He's the director of the forensic science program there. He explained all the complicated DNA stuff for me. Hall previously worked in the St. Louis Police Department crime lab for 12 years, where he did DNA analysis and screenings on thousands of cases.
There may only be a small amount of male DNA. And what YSTRs allows you to do is basically ignore or put aside all that female DNA. So you're only then left with looking at the male chromosome.
That seemed to be the case here. Lots of female DNA and just a tiny amount of male DNA. So they had to extract it to get the male profile. The lab also needed a sample from Frederico to compare to the vaginal swab. What's called a buccal swab was collected from him. It's a way to collect DNA from the inside of a person's cheek. It took a few years after the judge's orders, but the results from the vaginal swab came back in 2005. The male DNA in the vaginal swab was not consistent with the buccal swab of Frederico Lowe-Bey. 17 years after his conviction, he had evidence he thought proved his innocence.
I thought it was my ticket.
How sure were you at the time that you were going to get out of prison at that point?
I was absolutely sure. I said, man, I'm out of here. I said, I'm out of here. I don't care what nobody say. I'm out of here. That DNA don't match me.
But Thompson knew it wasn't a sure thing. The circuit attorney's office wasn't giving in.
Absent some sort of concession from the state, I knew that it was going to be an uphill battle. And, suddenly that that biological material that was found and discussed at the original trial suddenly became sort of like an ancillary issue. That's not important. That this DNA was found. It's not probative of any fact.
By the DNA not matching, then the circuit attorney's office, they screen file. Say that belonged to the victim's boyfriend.
If the sperm was from the victim's boyfriend, the state could much more easily explain why it didn't exclude Frederico as the rapist. So they needed a sample from the boyfriend to check that theory. And they didn't have to go very far to find him. During a hearing on Frederico's petition, the boyfriend was actually in the courthouse.
He was in the courtroom right next to us getting arraigned for a drug charge. And as a direct result, they asked him, did he mind giving swabs so we can run the DNA and match it up with him? He said he didn't mind. So they contacted him, kept him there for a minute, contacted the Metropolitan Police Department. They came over, swabbed him up, sent it off to the lab, and came back.
That sample also went to the Religene lab. If the results came back positive for the boyfriend, it would support the state's theory that the collected DNA was actually from a prior act, and that the rapist, who they were alleging was indeed Frederico, didn't leave behind any biological material during the crime. If you remember from the beginning of episode 2, the victim was walking home from her boyfriend's house when she said the men attacked her, and she was with the boyfriend for a period of time before the rape. The results for the boyfriend came back in May 2006. It reads the sample from the vaginal swab is not consistent with the boyfriend.
Didn't match him.
It didn't match. If this is the point you think Frederico is going to be exonerated based on DNA, you'd be wrong. So the scenario was either the state was going to have to admit they were wrong or try to offer up a completely new theory, but they weren't going to give in. So in October 2006, 5.5 years after Frederico's initial petition for DNA testing, the judge called for a hearing. She ordered the state to produce the victim to testify. That testimony would throw another wrench in the case. The victim came in and said that she had had sex with 3 other men right around the time of the rape 18 years prior. She said one of the men was named Fred Knox and that he lived in the Webb's housing projects. They took down as much info as she had so they could try and find this Fred Knox and ask him for a DNA sample. But it turned out Knox was dead. He was murdered in 1990, just a few years after the rape. They were able, though, to get a bloodstain card of Knox's from the feds, so they sent that off for testing. It was yet another chance to account for the unknown sperm. As far as the other 2 men the victim said she had sex with right around that time, she said she didn't know their names or who they were. She also claimed she didn't know their nicknames. That was a dead end for Frederico's defense. They couldn't go looking for people they didn't have any information on. The results for Fred Knox came back in May 2007. The efforts at this point to exonerate Frederico based on DNA was more than 6 years in the making. If the results came back positive for Knox, the state could say it proved their theory all the same. The DNA came from a prior act and the rapist didn't leave anything behind. But for the 3rd time, the lab excluded someone as the contributor of the sperm.
The irritating thing about the case is that the state was sort of able to change the narrative each time we excluded a particular contributor.
But they still couldn't say whose it actually was. And 2 decades later, that's still the case. It's the biggest unanswered question in a conviction that's got no shortage of them. A few months after the exclusion of Fred Knox, the judge was prepared to enter a judgment. After 6 years of DNA testing, hearings, and motions requesting Frederico's release, they were finally going to have an answer. Judge Joan Berger's 9-page judgment lists the arguments from the defense as well as the state. Frederico argued the physical evidence demonstrated the DNA belonged to the rapist. The state still argued, after multiple exclusions, that the single unknown male's DNA did not exclude Frederico as the perpetrator. Part of the state's argument was based on another piece of evidence that was tested besides the vaginal swab. The victim's underwear was also kept as evidence because they had a seminal stain on them. And the results when they tested the underwear was that it matched the DNA from the vaginal swab. And the evidence and testimony from trial were that the perpetrators removed the victim's underwear before the rape and she never put them back on. They were recovered at the crime scene and seized as evidence. So the state was saying that because the vaginal swab and the underwear came back to the same unknown man, that showed the DNA was from a prior act and not the rapist. When Judge Berger granted Frederico's motion to test the DNA 4 years earlier, she wrote that the DNA results would be exculpatory if the vaginal swab and underwear stain were 2 separate males, and if neither of them were Frederico. But since they were the same person's DNA, Judge Berger ruled Frederico had not proved his innocence. His motion for release was denied. In a 2009 KMOV story, the assistant circuit attorney who represented the state, Ed Pistacco, explained it this way.
Unlike CSI, which is a TV show, not every case where there's body-to-body contact is going to leave DNA evidence. Not unusual for rapists to fail to ejaculate. They don't always leave spermatozoa and seminal fluid.
Frederico's best shot at exoneration was gone. In Thompson's opinion, the hurdle they had to clear was just too high.
I think that the General Assembly was, had the best intentions when they wrote the law, but to make the standard, demonstrative of innocence, it's a very sort of in my experience, well, it's a legal standard or a burden of proof that is hard to define and hard to meet. Maybe if I'd written the law, I'd say, if the court finds that there's a reasonable probability that the verdict might have been different or the outcome might have been different, maybe that would allow more people, to get relief. If there is a serious question about whether latter-day forensic evidence supports the conviction.
To Frederico, justice was evading him. The DNA mystery has been hanging over his head for 20 years now. He can't get over the unanswered question.
And everybody is dodging the bullet. He throwing shots. Nobody wants to talk about the DNA evidence. Nobody wants to talk about who the DNA evidence belongs to. They don't even know who the DNA evidence belong to, Matt.
Despite the denial, Frederico's fight wasn't over. Centurion Ministries founder Jim McCloskey decided to start from scratch and hit the ground running.
We put our noses to the grindstone and reinvestigated the case.
That investigation would span several years, and possibly the most significant revelation came in early 2014. McCloskey was visiting the St. Louis Circuit Attorney's Office before preparing to file a petition for habeas corpus. According to McCloskey, they were trying to once again convince the prosecutor's office that Frederico wasn't good for this crime. While talking with an assistant circuit attorney in his office, there was a copy of the hospital report from Frederico's case sitting on his desk. McCloskey said he picked it up and started reading it. And on that copy of the report was a piece of evidence that Frederico's defense claims they had never seen before. 7 words in an acronym, scribbled in the bottom left corner of the clinical care record, would call the state's entire narrative into question.
We thought this might be a case breaker.
Nobody knew about this, Matt. Nobody.
Next, on Burden of Proof, one man's fight to show he's innocent. The document that Frederico calls the linchpin to upholding his conviction. You can listen to new episodes every Thursday wherever you get your podcasts or on firstalerts4.com. This podcast is produced and voiced by me, Matt Woods. If you want to get in touch, send me an email, matthew.woods@kmov.com with 2 T's on the first name. This is a First Alert 4 original podcast.